Are you tired of high-pressure tactics?
No, I'm not going to sign that. It's too much.
At Community Auto Group, you'll find we have a straightforward approach.
If other dealers have made you uncomfortable, give Community a try. You'll enjoy your experience here and find a straightforward deal that's right for you, not high-pressure tactics.
Community Auto Group, straightforward deals from the straightforward dealer.
So in 2010, Davenport amended their city code to try to find new ways to deal with their neighborhood enforcement efforts and created an ordinance entitled nuisance properties that define properties where multiple nuisance and criminal activities occur, and also enacted an ordinance defining a nuisance gathering and disorderly premises so that they could deal with situations when multiple gatherings occur on or near a certain property on a regular basis. We went to Davenport, myself, Captain McKelvey, and Mr. Quayle, back in December to learn more about their program and how they've been enforcing it, and they have found it to be very successful.
Hello everyone, I'm Mike McKelvey from the Police Department. I'm going to talk about nuisance gatherings and disorderly premises. Now if you guys can see this, there's some theories in criminal justice. One is the crime prevention theory. What they're going here is that there's three sides to a triangle to have crime. There's going to be a target, there's going to be desire and opportunity. How the theory goes is if you take out one of these sides of the triangle or reduce it, that'll hopefully reduce the chance of crime. So here, using this theory, we're trying to reduce the opportunity for nuisances and crime to occur and lessening the desire for criminals to break the law or commit nuisances and increasing accountability, which decreases the desire for property owners to ignore or do little or redress inappropriate activity on their property. Now again, using rational choice theory, which is another criminal justice theory, it'll suggest that guests, communities, and property owners will weigh their options once sanctions impact their willingness to commit an inappropriate act or allow them to keep occurring once the property owner has been notified or served an abatement notice. So usually what goes along with these is some type of notice to both the tenant or occupant, permittee or host, and the property owner. The theory is that they're notified this is an illegal act, it needs to stop, or else more serious sanctions may come. Hopefully they'll be rational and stop it. As we all know, some people don't take a hint and it'll keep going. That's why there's more severe sanctions.
As I stated earlier, the focus here is really on the troublemaker, not necessarily the owner, meaning the landlord, the owner-occupant, or a business owner. This abatement plan requires notification, and it encourages the involvement of the property owner in negotiating a mutually acceptable abatement plan with staff. It does allow attachment of abatement costs and civil fines to the property if the property owner is the perpetrator or fails to adequately abate the nuisance in the allotted time frame. So we can use liens, we can use other means of recovering the fines.
Everybody owns their own condominium. If we have an owner that is causing a problem himself, can the rest of us be held responsible for that?
And again, I don't know the specifics of your condominium, if there's association rules or anything else. If that was a case where somebody, like let's say an owner-occupied home, and they kept causing the problems, obviously we can't get them to move, so we would probably level fines against the owner of that problem property.
I've had kept on 89-6 and in other locations of the proposed ordinances, it states at least 3 or 4 different places that property owners could be responsible for acts committed by others that are at least 1,500 feet away from the property line. I'm wondering how that would work in a court where a person an owner of a property, where the act is not committed, would be somehow brought into being fined or whatever from a property that is 1,500 feet away. I'm an owner of some properties. I wouldn't have any jurisdiction as to how to control or mitigate or any other thing a property that's 3 blocks away from me. in order to not only to comply with this new ordinance, there has to be clear and concise instructions in the ordinance as to what we can and cannot do. I would ask for City Council to make sure that they look at all these things, and I intend to leave a packet with each of the City Council members at the City Hall, so that they can be reminded of these things that I'm bringing up tonight, and you can see that there's not clear and concise answers to some of these questions. And in my closing remarks, some of it is just summarizing my activities over a period of, when you made a comment that there was a lot of properties in town that were somewhat described as nuisance properties already. I don't know this. I'm really ignorant about the fact that they exist. I know that sometimes things can get out of hand, but I didn't know that it was created at the point where it was creating a whole lot of neighborhood problems. And so I would ask that the City Council look at the cost of additional time and the increased number of new employees that are going to be required possibly to do what all of the things that this new proposed ordinance is going to require. Landlords are providing housing to about 1 of 3 residents in Mason City. If we look at the vast numbers of apartments, about 4,600 of them. And we have a city rental program that landlords pay just under $80,000 to license them. I think the city benefits from this program. I haven't seen any direct benefit from ourselves yet, and I didn't expect any, because we look at our properties as whether they are code compliant insofar as universal building codes and things like that. I thank you for the time, and I ask that council members mitigate any of these things that I brought up to the point where we have the landlords will have a clear and consistent understanding as to what their obligations are, and that we don't end up becoming a victim of circumstances here, and where our cost of operation is needlessly increased. Thank you.
What I'm saying is, you guys brought it up to begin with, that you didn't know how you was going to enforce this legally, and I guess my question is, yeah, how are you going to do that without litigation?
The enforcement situation has been tried in other communities, and so and that's one of the things that Randy reviewed, and also Captain McKelvey, as they went through the process. It's been tried in other cases, and so we feel that the legal standing with the provisions that are in the ordinance allow for it to be enforced.
Is there any way they can make a motion on a probation time on this, a year, year and a half, whatever, instead of just making this a resolution that once you pass it, if you do pass it, then it's for good? I really think, here we are, we're Mason City, we're not Davenport, we're not Des Moines, we're our own entity, and I just don't feel that we should be following others all the time, all the time, out of retrospect, just to do what they do. And we've had problems like this for years. We can figure it out. It's our problem.
Right.
It's nice that you go see what these other people do, but to enforce these things or impose them on us, because especially with this not being a city vote, it's a council vote, unless we get, what, 600 signatures?
Well, it's an ordinance, so there wouldn't be an issue in that respect. It wouldn't go through for public vote.
I don't know. I was told differently.
The situation resides with the council to make that decision as to whether or not it would go into place. And anytime an ordinance is approved, it can be changed 1 month, next, 3 readings if there were changes that needed to be made. When you say permanent, it is not permanent. It's permanent until a city council would make the decision to make the change again.
My name is Dan Brick. I own Brooks Bar and Grill in Mason City here. I too have an issue with the 1,500-foot rule, as in, as far as with my business, there are plenty of other businesses within 1,500 feet of my business that have just as much trouble, if not more. How you plan on segregating who did what and when? I mean, I understand that, you know, you're trying to work with the property owners, and that this seems to be focused a lot on the residential, but you've also blanketed it to affect all businesses. And unfortunately, in my type of business, I tend to use the police force, unfortunately, on a regular basis. And that's a concern of mine too, with the cost. You know, I live in town, I pay property tax on 2 properties, and business property at that. So that's another problem, I'm saying. As I said, you know, like with most bars, there's usually another bar within 1,500 feet, sometimes more than one. So I guess that's a concern of mine.
I don't know if Randy or Mike can answer this concern.
I think the 1,500 foot, you have to read the surrounding language in all situations where the ordinance says within 1,500 feet of the nearest point on the property by an interested party or their permittee. In other words, it just can't be someone that walked in from 3,000 feet and came within 1,500 feet, and that wouldn't be your problem. The enforcement officers have to identify one of your customers, one of your patrons, someone that is emanating from your business. The reason for the 1,500 feet is to avoid the loophole of somebody selling drugs or passing out booze to underage people from walking out your door and walking 1,501 feet away, or 1,499 feet away, and doing their illegal activities and then coming back. And that's
if some of these things went to a higher court, much of this ordinances would be declared unconstitutional. For example, you still have private property is private property. You cannot just authorize anybody to go onto a property. The property owner still has the right to deny you access. You're trying to encompass too much in these ordinances, and it hasn't been legally fine-printed. You may get a local judge who has formerly represented you for an insurance carrier who might, thinking it would never go to the Supreme Court of Iowa, but this thing will not stand.
I basically am primarily a constitutionalist. The first thing I do is look at the Constitution when anything comes up. However, just like that lady, I'm working for a lawyer for the state of Iowa judicial system, and she is terribly, terribly correct. There are so many things in here that are just so wrong that it's, like one of the founders said, it's better to pass no law at all than to pass a bad one. And this is bad. The landlord, the man who owns rental property, every issue he brought up is in here is wrong. You cannot expect or authorize a private citizen to take responsibility to do a police officer's job on the entirety. And that's pretty much what you're doing. You're sharing it over to the landlord. If the landlord would evict them, if we tell them they've got a bad tenant because we keep going out there, then it's up to you to handle that job and solve it. First off, how's he going to do it? The renter is paying his rent. He's not damaged the property. There's very little else that our landlord worries about except those particular items. As long as he's getting his rent on time, as long as he's not damaged the property, what law has he broken? The thing what you're doing is telling that landlord, we're going to give you a notice that you need to solve this problem. It's not his problem. It's the community, the police chief, the sheriff's office, the legal system that is not included in here. You're asking that landlord after his notice on an abatement or whatever you call it, that he's going to come in front of you, the mayor and the council, to see if he has a right to rent that property. That's a judicial. There's nothing justifiably judicial in what you've written in here in regards to him renewing his license. That in itself could be taken to court because you're just doing all wrong. What legal rights under your specification does a landlord have to go to these people and say, I've been notified you're a nuisance or habitual disorderly. I have to remove you. The man's not broken any law in a contract with the landlord. So what is it you expect him to do?
Is that a question? I mean, is that?
Yeah. What do you expect the landlord to go to that tenant and say, you're out of here? And he's going to say, why? Because the city said so.
Usually there's language in a lease though. If the landlord wanted to, there's usually language in the lease that the person has to obey all laws and not cause a disturbance to other neighbors or whatever on the property. My experience from dealing with some landlords, we had one where shots were fired in the yard, somebody was stabbed on the front porch right next to the front door. There was all kinds of other issues going on in this property back in 2010. That's when this first came up. I called the landlords in, it was a husband and wife, they were small-time landlords, had a few properties. I laid out a whole laundry list of all the stuff emanating from their property, all the stuff their guests, permittees, visitors, and their tenants were involved in. And what the landlords told me, they're really good tenants, I'm not going to evict them. Now what you're saying, as long as the rent comes in, it's all good. There's other stuff in the lease. If the landlord wants to, they can do this. What I've heard from some landlords, though, they're afraid to evict the person because A, that's going to increase their costs to take them through the civil process of court. They don't want to spend any extra money. And then B, sometimes if they do that, the tenant will retaliate. So to be fair, I think that's the other half of the equation. Some landlords don't want to take action either because it'll increase their expenses or there could be some retaliation. I think Ray can tell you there's been some heck of some retaliation to some of these places from tenants who get mad over the eviction process.
And that just justified my comment that you are literally forcing under this particular ordinance a landlord to put his own life, liberty, and property in jeopardy. You're creating a situation whether or not he has it in a contract or not. You are saying to him, you do something about it or we're going to penalize you. Now the man that is doing something bad like those, obviously those things you suggested, those are felonies, serious misdemeanors of sort, mostly felonies, of which you have listed in here. So that landlord is going to pay a police service fee for doing your job because he went to this apartment. Now here's the deal. 2 doors down from me is a rental. And the lady lived there all by herself. She's a grandmother. Every so often her daughter and granddaughters would come by. But she went through 3 weeks. Police officers called there 3 times because her ex-crazy drugged-up ex-husband, kept coming by and creating problems for her. She would call the police. So in this scenario, that's a nuisance residence because they were there not just once a year, twice a year, or 3 times. They were there 3 times in 4 days. The 3rd day he had beat down, knocked down, kicked down the back door of the residence. So who are you going to penalize here? You want the landlord to come over and say, well, this is a nuisance residence. We need to have you move out because your ex-crazy husband is a problem.
Ma'am, it does not say that in any way, shape, or form.
It is so unclear when you read it that you can actually come up to that scenario in the wording that you have in here. I
think if you look at the definition of a host, of a permittee, and an interested party, you would find that in the circumstances that you describe, that the only person who could be held liable, and I'll defer to my, is the person, the crazy ex-husband. The landlord is not going to be held responsible for that.
Okay, but the woman's going to be?
I'm sorry. You're saying that she might be imposed for police protection fees, though, right?
No.
No, I'm saying.
Only after a notice of abatement has been filed and the problem continues, even after that point, that's when police service need can come into effect.
So after you file an abatement, no matter how many times you use the police force, there'll never be a,
yes.
assuming you're following your abatement thing.
Right, correct.
And if you don't, and then the one part where it said you have a 1 year, you can use the police one time, and it's exempt for anything over a year.
But in the situation she described, there never would be a notice of abatement, because the problem was not emanating
So
from
it
that
wouldn't-
property.
Okay, so
There wasn't a welcome person there, it wasn't a guest there, no one wanted the person there. It wouldn't emanate from that property, there wouldn't be even a notice.
Well, as I said before, and she's pointed out, you blanketed every piece of property with the same rules. Whether it's residential, business, Walmart. I mean, I'm sure Walmart gets called out, police are out there, I know, practically daily.
You know,
So
the comment of the city council was they have, pretty much know the areas that they have these kind of problems. That a particular address that they're constantly having to go to that's your job. The landlord has nothing at all responsible for the actions of that renter in any sense of form. And if the ACLU gets a hold of this, they're gonna rip it apart. And they will. They will, because you are technically, even like that woman, or these other people that have had a police officer there, and you've notified the landlord that, okay, we were here and we've been here before, but we're going to give you a notice that this is a nuisance property. So we don't have to keep going out there. You take care of the problem. That's your job. That's what we pay a policeman for. I'm sorry.
Again, if something like that happened where the same person was coming over uninvited 3 times, we would ask that female, do you want to press charges? Do you want the person on the property? Do you want to ban them? If they say no, he can come over, but he just, we would need some help from the property.
You've listed all sorts of federal felony cases in here, in one of these that I've got here. They're all felony state code laws, every one of them, in the major one, where you're only supposed to have them out of 12 months before you're going to give the landlord an abatement. Okay, let's say in a 12-month period, you have a man arrested for a felony, and we've had a few cases here. They've been off, out of jail, they've been on bail for months. It's a felony charge, but the judge said they're not going to go anywhere. They give him a post or bond, and he gets out, so he goes home, which is the very address that the felony was created. The landlord now knows about it, but he's back there, and another felony occurs. Maybe it's even worse type of sexual or physical abuse, which you've got listed in there under the Iowa Code. But he's still there. So you're going to call the cops for a second time that you are not entitled to? The landlord is not going to want you to, because he's going to give this abatement and say, what am I supposed to do? She's the one in trouble. She's the one, but she is, you've got family. How did you word that? Under that, just a minute, I'll find it. Anyway, a member of the family under that, what is it, interested party or something? Let me find it. All I'm saying is that you're not, I don't care what Davenport's doing, but I'll tell you what, if enough news comes out about what they are doing and the public is just ignoring, because it's not affecting them. As long as it don't affect the normal citizen outside of one area of Mason City that don't like what's going on, because the police are there several times a month, they're the ones that care. The rest of Mason City care less. I was trying to interested party. Means owner, tenant, contract purchaser, spouse, family member, or housemate thereof. Now, how do you include all those people if it's man and wife living there? He's been arrested, he's been released, and he's living there. And he goes out, how many times have you seen it? They've been re-arrested for something else. I know you're not seeing my point, but believe me, if this ever goes to court, there's going to have to be some changes in these wordings. There's, like, I'm sorry your name, but like you said, it's not specific, it's not clear enough, it's not definitive enough. Thank you.
Mr. Troika, I just have a simple question. I think as a landlord, we're supposed to abate the problem. So the only thing I can understand to do, unless you have those suggestions, is to remove the tenant. To remove the tenant, you have to give them a 30-day notice to quit, which after 3-day notice, 3-day notice to quit or correct the problem. If they correct the problem, they can stay. This can go on indefinitely, basically, or give them 30 days notice to move. Is Ray going to assist in that process? That's what I'm missing, I guess. If Ray is going to assist in the process, give them 3 days notice to leave, and also this discrimination thing with our Human Rights Department, I just feel I need the city's backing. I mean, I like the idea, but I just want to make sure that I don't know. There's just things missing. I don't quite understand yet.
Right.
There's just too much going on with such little time to get together and put our heads together. And that's all I got to say. Just hope you think about it even more than what you're doing.
I just want to add one thing. I'm not trying to be gentlemanly in any way, but a good constitutional lawyer, take Article 1 or Amendment 1, 4, and 14, and they will spend some goodly money trying to defend what you've got right now because of the way it's so big. If they could just read it.
If you're going to speak very long, we need you to come up here.
Just got 2 questions. I want to know, you mentioned stakeholders several times, and I don't find it in the definitions. So I just wanted you to explain it. What is your definition of stakeholders? And sounds pretty muddy. What percentage of the citizens of this community do you feel understand this ordinance 100%? And Councilman John Lee, he brought up a real good point. We don't want to legislate people out of town. I believe it sounds like this ordinance just scare people right out of town.